Chapter 11 of the Construction Business and Law Manual for Nevada. Nevada Labor Laws. Overview. In addition to the federal labor laws, the state of Nevada has its own set of labor laws. These laws contain state requirements that an employer in Nevada must meet, in addition to following the provisions of federal law. For information about federal labor laws, refer to Chapter 3, Labor Management. Some of the Nevada laws concerning employer-employee relations deal with such items as wages and hours, employment of minors, workers' compensation insurance, unemployment compensation, new hire reporting, apprenticeships, and equal rights requirements. Wage and hour laws. The general provisions that govern compensation, wages, and hours of employment in Nevada can be found in NRS 608. Compensation, wages, and hours. Highlights of this law include the following requirements. An employee may not discriminate on the basis of sex for equal work, skill, and responsibility. An employer must pay 1 1/2 times an employee's regular wage rate whenever an employee works more than 40 hours in any scheduled week of work, on more than 8 hours in any work day. Employees must provide a meal period of at least 1/2 hour during an employee's 8 hours workday, and a rest period, insofar as practical, in the middle of each workday. Whenever an employer discharges an employee, the wages and compensation earned and unpaid at the time of the discharge are due and payable immediately. Whenever an employee resigns or quits employment, the wages and compensation earned and unpaid at that time must be paid no later than the regular payday or 7 days after the employee resigns or quits, whichever is earlier. Notice of paydays and time and place of payment must be posted. Every employer must establish and maintain complete employee records of all wages and other forms of compensation. The information must be furnished to employees within 10 days after a request is made. Records of wages must be maintained for a 2-year period after the information has been recorded, and an employer may not willfully refuse to pay wages due the employee. Nevada has adopted, in accordance with federal law, the minimum wage which may be paid to employees in private employment within the state. The Labor Commissioner shall prescribe increases in the minimum wage in accordance with those prescribed by federal law, unless he determines that those increases are contrary to the public interest. Refer to Chapter 3, Labor Management, for the federal minimum wage. Employment of minors. NRS 609, Labor and Industrial Relations, contains rules concerning the employment of minors. The statute follows the laws of the United States Department of Labor under the Fair Labor Standards Act with additional restrictions. Refer to Chapter 3. Labor Management for information about Fair Labor Standards Act. Following is a summary of NRS 609. No child under the age of 16 can be employed in an occupation that is considered to be dangerous. In addition, this law also applies to particular trades assumed to be unsafe by the Nevada Labor Commissioner, and to any minors working as an employee for a contractor or independent contractor. No child under the age of 16 may work more than 48 hours in any 1 week or more than 8 hours in any 1 day. And a child under the age of 14 cannot be employed during school hours unless permission has been granted by the school district or by order of the juvenile or family division of the district court. Most of the jobs related to the construction industry would probably fall under these restrictions. It is better to err on the side of caution when considering a child for employment in a construction environment. The employer must also pay careful attention to the differences between federal, state, and local laws regarding the employment of minors. If there is any doubt about which of these laws should take precedence, the employer must ensure that the law providing the most protection to the minor is the law that is followed. Workers' compensation insurance. Employees who are injured or disabled on the job are provided with fixed financial awards through workers' compensation laws. These laws are also designated to reduce the need to sue. Workers' compensation laws also provide benefits for dependents of workers who are killed because of work-related accidents or illnesses. Some laws also protect employers and fellow workers by limiting the amount an injured employee can recover from an employer and by eliminating the liability of coworkers in most accidents. Each employer is required to post and maintain a printed statement concerning regulations or other matters prescribed by the regulations in place readily accessible to employees. State governments have enacted workers' compensation statutes that have established the framework for most employment coverage. Nevada law requires all business owners in the state to obtain and maintain workers' compensation coverage, especially those with one or more employees. There are very few exceptions to this requirement. Business owners who fail to comply with this law may be required to pay fines of up to $15,000 or may have their business ordered closed until the insurance has been obtained. Employers also may be held financially responsible for all costs associated with a work-related injury to an employee if the employer has no coverage in force. Refer to NRS 616D.200 for additional information. Since Nevada no longer has a state-funded insurance program, the Nevada Division of Insurance, DOI, allows for employers two options for obtaining coverage. Employers may obtain workers' compensation insurance from a private insurance company or provide coverage for their employees through self-insurance. For smaller businesses interested in becoming self-insured, there are associations of self-insured employers. These associations are composed of groups of employers, generally in the same type of business, who make up the membership of the association. Current listings of approved self-insured associations and self-insured employers may be found on DOI's website at http://doi.nv.gov/self-insured/. To obtain workers' compensation insurance, an employer should contact the agent or broker who handles the insurance company's insurance. If the insurance is not available through normal channels, the employer should investigate obtaining workers' compensation coverage secured through the assigned risk program, i.e., the involuntary or residual market pool. Additional information about this option may be obtained from the broker agent. The National Council on Compensation Insurance, NCCI, administers the assigned risk program. The NCCI can be contacted at 800-622-4123. Refer to https://www.ncci.com/pages/APB_assigned risk_listing.aspx. Nevada Unemployment Compensation Law. In general, the purpose of the federal state unemployment insurance program is to provide temporary benefits to eligible workers who become unemployed through no fault of their own. Nevada administers a state unemployment insurance program with guidelines established by federal law. Unemployment benefits are funded solely from a tax paid by employers. Nevada unemployment insurance law determines standards for eligibility, benefit amounts, and the length of time for which benefits are payable. To meet eligibility requirements, the unemployed workers must meet the state requirements for wages earned or time worked during an established one-year period of time, referred to as a base period, have become unemployed through no fault of their own as determined under state law, and meet other eligibility requirements of the law. Benefits. In general, benefits are based on a percentage of an individual's earnings over a recent 52-week period, with a maximum amount determined by the state. Benefits can be paid for a maximum of 26 weeks, although additional weeks may be available during times of high unemployment. Unemployment benefits are subject to federal income taxes and must be reported on the employee's federal income tax return. The recipient may elect to have tax withheld by the state unemployment insurance agency. http://www.leg.state.nv.us/nrs/index.cfm. For information about federal unemployment coverage, refer to Chapter 3, Labor Management, and for information concerning payments required of employers, refer to Chapter 12, Tax Laws. New hire reporting. As of October 1st, 1997, federal welfare reform legislation requires all employers to report certain information on newly hired or rehired employees to a designated state agency. In Nevada, new hire information must be reported to the Employment Security Division of the Department of Employment, Training, and Rehabilitation. The Child Enforcement Office of the Nevada Welfare Division uses new hire information and the National Directory of New Hires to locate parents who are not paying legally required child support. The Internal Revenue Service requires that all employers report any new employee for whom a W-4 is submitted. For any person hired or rehired on or after October 1st, 1997, the required information must be reported within 20 days. The required information must be reported within 20 days of the date of hire or rehire, or twice per month, if the reporting is done magnetically or electronically. In Nevada, new hire reports must be sent to the following agency: Department of Employment, Training, and Rehabilitation, Employment Security Division, New Hire Unit, 500 East 3rd Street, Carson City, Nevada, 89713-0033, phone number 775-684-3849. Employers may obtain answers to questions regarding new hire reporting in Nevada by calling 888-639-7241. For information regarding the Child Support Enhancement Program, call 800-992-0900. Nevada Administrative Code NAC 610, Apprenticeships, contains the requirements for the utilization of apprentices employed on a project. Topics covered in NAC 610 include ratio of apprentices to journeymen at a job site, standards used in apprenticeship programs, forms of agreement required of all apprentices, registration of apprentices transferring to Nevada, dismissal of apprentices, required wages and benefits for the total period of apprenticeship, and policies and procedures that must be followed to promote equality of opportunity in apprenticeship programs. Ratios of apprentices to journeymen. In all apprenticeship programs in the construction industry, an employer cannot exceed more than one apprentice for the first journeyman at the job site and not more than one apprentice for every 3 additional journeymen. Apprentice wages. Employers must pay an apprentice a beginning wage that is at least 35% of the rate for the journeyman in the same trade. During the total period of apprenticeship, an employer must pay each apprentice a wage which, when averaged, will be at least 50% of the amount which would have been paid to a journeyman during that period. The minimum wage for an apprentice in the construction industry varies depending on the type of project for which the work is being done. The wages required to be paid for apprentices on all types of projects, both private and public, is set forth in NAC 610.485. Nevada Equal Rights Commission, NERC. The Nevada Equal Rights Commission, NERC, created in 1961, oversees the state's equal rights program. NERC handles discrimination complaints relating to race, national origin, color, religion, sex, gender, and/or orientation, age over 40, and disability when the discrimination is linked to employment or to the Americans with Disabilities Act, ADA. NERC, Nevada Equal Rights Commission, receives attempts to settle and investigates complaints of alleged unlawful discrimination in employment. For additional information, contact either the main office in Las Vegas or the regional office in Reno. Nevada Equal Rights Commission, 1515 East Tropicana Avenue, Suite 590, Las Vegas, Nevada 89119, telephone 702-486-7161. Nevada Equal Rights Commission in Reno is 1325 Corporate Boulevard, room 115, Reno, Nevada 89502, phone number 775-823-6690. Email address detradmn@nvdetr.org. Website address http://detr.state.nv.us/nerc.htm. Nevada Job Connect, one valuable business resource available to employers in Nevada Job Connect, which is charged with overseeing and providing workforce development services to employers. Nevada Job Connect offers recruiting, retention, training, and retraining, and outplacement services, as well as useful information about labor law and labor market statistics. Nevada Job Connect is part of a local/state network dedicated to developing the workforce of Nevada. The network is comprised of a statewide efforts of the Workforce Investment Board, coupled with planning and service provisions on a regional level by 2 local workforce boards. This network provides access to local workforce solutions and statewide services in one location at Nevada Job Connect offices. Primary services of Nevada Job Connect and its network partners are funded by federal tax revenue and are generally free to all Nevadans. Reno Job Connect Office, Reno Town Mall, 4001 South Virginia Street, Reno, Nevada 89502. Phone number 775-834-1970, or Las Vegas Job Connect, 3405 South Maryland Parkway, Las Vegas, Nevada 89169. Phone number 702-486-0100. For additional information, the Nevada Job Connect website is http://www.nevadajobconnect.com. Thank you so much for listening to Chapter 11. Please tune in to Chapter 12 of the Construction Business and Law Manual for Nevada.